বলছি আমরা স্টার্ট করে দিই, প্রিন্সিপাল স্যারকে তো কানেক্ট করা যাচ্ছে না।
Yeah, let's start.
Let's start. Okay. A very good morning to everyone. Once again, we have been assembled here for the final days of our FDP program. Today we have a very new speaker, new panelist with us, Mr. Prakash Devroy, and definitely we have one more panelist with us, Mr. Utsav Banerjee. If you have any queries regarding any of the sessions, you can put your questions in the chat box, or you can directly ask the questions. All the three panelists are here to address all your questions today. Today we will have a session on intellectual property and startup, and the next day we will have a session on technology transfer. Now I request Ms. Dr. Pinaki Ghosh to introduce our today's panelist. Over to you, sir.
Good morning, dear participants. Today the topic is the startups and the intellectual property. Tomorrow he will going to talk on technology transfer and intellectual property. So today's speaker is Mr. Prakash Devroy. He has industry experience around 7 years after his BTech and LLB. He did his LLB from IIT Kharagpur Intellectual Property, Rajiv Gandhi School of Intellectual Property. After that, he joined a couple of organizations, including KPMG and SFL LLC. He is a BTech in Computer Science and Engineering from WPUT. And currently he is a senior associate in Cognizant Technologies. So Prakash will going to talk today on intellectual property and the startup. What are the nuances, what are the advantages, what are the things has to be taken care by the startup. So this will be, he will going to talk on that. Over to Prakash.
Very good morning, dear participants. I will be today speaking on intellectual property and startups. So startup is a very huge term which encompasses a lot of sectors of companies. It's a very new term that has came up recently since 2014 and 2015 policy changes at the governmental level. Previously, we used to deal more with MSMEs or national small scale industries. So first thing we need to understand, or we need to ask ourselves, who is a startup? So if you ask me who is a startup, so the first thing comes to our mind is, small companies which are operating on new age technologies, which are doing pretty well in the market, and we are well aware of it. Like Flipkart was once a startup, Google was once a startup, and Yahoo was also once a startup. But at this point in time, these companies, we cannot call them really a startup. They are right now well-established company with billions of dollars of market capitalization. So if you ask me who is a startup, we need to look into the legal definition of a startup, and that too in India. So if we look into the acts of India and the legal framework, we can actually there are 4 qualifying parameters for a startup. First is the company age, then which all type of companies that can be a startup, what are the annual turnovers, and which all companies that cannot be a startup, even qualifying for the first 3 criteria. So if you ask me, what should be the company age? It should not be more than 10 years from the date of incorporation. And only private limited companies, limited liability partnership, or registered partnership firms can register themselves as startup, provided they are not more than 10 years of age from the date of incorporation. So another question might come to us, then what all other types of companies that we can register but cannot be a startup and can be less than 10 years of age, that are a 1% company or normal one. So normal 1% companies. And then there is also a revenue point of view. Revenue cannot be more than 100 crores. And these companies should not be formed by splitting of already existing business. Like, big business houses, they cannot come up and, open a subsidiary to create a startup. So if you ask me, you give me an example wherein such thing has happened, a big business firm, they have opened up a new business, but it couldn't be called as a startup. For example, Reliance opened up Geo in 2009, 2010. So probably it was not yet 10 years old in 2017, but it was a subsidiary of RIL, the larger Reliance group. So that's why it couldn't qualify itself as a startup. But at the same time, if we see Hike is a major investment of Mr. Bharti Mittal, the promoter of Airtel, but it was not so it is not a subsidiary of Bharti Group. So it has been registered separately by his son, and where Bharti Mittal is one of the investors. So Hike has been registered as a startup. Now it's not only about registration or revenue criteria or age of the company or type of the company. There are other parameters too. So if you ask me what are the other parameters, so other parameter is that they should be working on innovative and scalable inventions. So what is innovative and scalable invention? They should be working on something that includes development or improvement of a product, process or service. I am repeating this term product and process because probably during the last few days of our webinar on intellectual property, we are very well aware of the term product and process, and we know patents can be filed on a product and a process, right? Or service, and or it should be scalable, and it should create a high potential for creation of wealth and employment. So not only innovative, it should create wealth and employment. So this entire startup scenario, if you see, is aligned with the larger policy of Make in India, of creating employment. But not only employment of service, but also employment of innovation, wherein there will be development and improvement of product, process or services. So once these things are established, then only a corporation can go and file a document with the Startup India office and can then they become a registered startup. Once they become a registered startup, lot of benefits follow. So I am moving to the next slide to show you the benefits. So what are the major benefits? So now I will be strictly speaking on intellectual property terms. I am not speaking on the other benefits of startup when it comes to bidding for government projects, where the like earnest money deposits are very less compared to established firms or MSMEs, or there are tax and havens for 5 to 7 years, or reduced rates for government SEZs. I am not going into detail of overall holistic benefit of a registered startup in India. I will be speaking morely on the benefits of in terms of intellectual property. While they are going to file the intellectual property, what kind of help they will get. So there are two major help if you're looking into. One is that fast tracking of startup patent application. So startup it can be actually fast tracked through a established patent process. So what is the help of startup for doing so? Like an expedited examination process is there. So the help they get is on the rebate on filing of application. What is the rebate on the application rebate on filing of application? They get 80% rebate on the government fees. They get 80% rebate on the government fees for filing their intellectual properties. Right now, so there can be a question, I am going to go and file my intellectual property. I am getting 80% rebate to file my IP. But the problem comes is who will draft my patent probably? Who will actually bear the professional cost? So for that, the intellectual property office has also listed a panel of facilitators that will be helping in IP filing. But till now, so dealing in the market, the IP facilitators work has not that been great. But still, as we are in a nascent stage, and a typical duration to get a patent grant, even if your fast tracking is around 4 to minimum 5 years in India. So these things have not yet been uncovered, but probably in future what we see is that it will be uncovered. But there are several state government and central government scheme of actually for subsidizing the professional fees. So at sometimes the facilitation costs are actually beared by the government. Like there are specific government packages of government of Haryana, there are specific government packages of government of Delhi, where a registered startup can get a lot of benefits. Like in for West Bengal, NASCOM as a NASCOM has an initiative that is 10,000 startups. Over there also they actually use the Startup India route to get and garner a lot of benefits. Moving to the next slide. So the question is that, so when we are speaking of intellectual property, we are speaking of everything in startup sphere. So why file an IP? Why think about intellectual property in startup? We can open a startup and we can do our very well business and get all the tax benefits, all the revenue benefits, all the registration criteria benefits, and move ahead. The question is that in the basic criteria that has been mentioned is that a startup should work towards a development and improvement of a product, process, or service. So how do you establish the particular technology field in which the startup is working is actually working towards a development of a specific product, process, or service, and something that has no one else has done before. We can actually speak that we can do our market study, we can do our market study, we can do our market landscape and show that no one else is working in the particular market area. What if someone has filed a patent on a particular technology that you are working? What will happen then? Then that third person has the right to actually stop you from entering the market. Entire investment will go low. For that, in order to establish that you are actually working on the development and improvement of a product, process, or service that someone has probably not envisioned previous, an IP analytics is required. So what is IP analytics? So there are multiple ways we can think about it. There is an aggressive strategy part and there is a defensive strategy part. So before moving into the aggressive and defensive strategy of IP analytics and how it is used in the startup circle, and how these analytic strategies are used to establish and register a startup, I would actually keep the forum open for some questions. If you have any questions, please put forward. I will be taking 1 or 2 questions now of any queries. Please raise your hand if you have any queries. Okay, sure.
Hello.
Hello. Yes, please.
Sir, good morning. My question is, you had told that about startup, they are giving subsidy of 80%. Is it for everybody or there are some conditions?
No, it is for all registered startup. The conditions are the organization should not be more than 10 years of age. It should not be, actually broken from an earlier organization, basically a subsidiary of an earlier established organization. And it should be a registered company, private limited company, or a registered partnership or a limited liability partnership. And it should work towards a goal of developing an innovative product, process, or services and generate wealth and employment. These are the criteria.
That means proper examination is there before giving the subsidy.
Yes. The proper examination takes place. For that, you need to file proper, documentation with the particular authority, that Startup India office, where you need to establish your case that why you should get all these government benefits. So see, that's why I was explaining that the terminology startup is so randomly used in this market. We rarely go into the qualification of a startup. There are companies which call themselves as a startup, but they don't register themselves as a startup with Startup India. All new companies are not startups, legally speaking.
Only established companies.
The companies which has actually registered itself with Startup India, will get the list over there. those are the companies that can actually legally call themselves startups. Else you can use we can use the colloquial term that we are working as a startup, but we are not. Basically, an English meaning and a legal meaning of startup. That's it.
Okay. Thank you.
Any more questions, please? Else I will move
Yeah,
to the
Focus,
next. Go ahead.
Go
Okay,
ahead.
sure. Sure. One second. Okay. So when I'm speaking about the aggressive strategy and defensive strategy, so what is an aggressive strategy and what is a defensive strategy? Aggressive strategy is something that when we use that particular asset that we are registering to promote ourselves in the market, and defensive strategy is something that we are using. We are basically looking into an area wherein people cannot come and stop us from doing our businesses. Probably the technology areas are very close to each other. So what is a landscape? To understand the first aggressive strategy we are telling, I will be speaking about is a landscape. A landscape is something that we do a very basic analysis to understand who all are the players in the market who are operating in the same technology area. Who all are their players there in the market, which all jurisdiction they have filed their patents. I am quite sure by this time everyone is aware that patent is a territorial right. There is nothing called a global patent. We go and file in the patent office of each and every country. And for Europe, we mostly file in the EPO. So which all landscape, which all countries they have filed a patent application, and what is their grant ratio, and for how many years they have been filing, when they have filed aggressively, when they have not. So once you get the idea of the landscape, like we know the boundary of our innovation, where all people are working, what all technology area they are working, why they are working, everything. We try to find the white space. What is a white space? White space is probably that particular technology area that no one has thought about. Like everyone is manufacturing a bottle, but no one has manufactured the cap of the bottle. And if everyone is manufacturing a bottle and the bottle's cap, but they have no one have thought about how to make holding of the bottle more easy. So these are basically small white space areas that gives us edge of thought. Like for example, if you remember, I am not going into technology landscape areas because I'm trying to relate. I'm giving example of consumer products so that everyone can relate with. Like for example, like the Fanta bottle that came up, with a bulging on the top, and in the bottom it was made in such a way people can hold it out. So these are small white spaces people identify from a landscape. So once they identify white spaces from a landscape, they go and file patent applications. So they won't be going and filing random patent applications. First, they will try to establish which is the state of the art, and they will try to have understanding based on the state of the art, what is the chances of myself getting a patent out of it. So patent grant out of it. So that's why what they do a patentability analysis. About the patentability analysis, they understand what is the novelty of the application, whether it's obvious or not, and what is the economic criteria, whether it is capable of industrial application or not. When they think that all the criteria they can walk through, then they probably go and file a patent application. And also, it's not always about getting a patent grant. Why if we are even filing a patent application and we are not looking for a grant, we can actually showcase it for business. We can showcase this for technology prowess. As an academic institution, filing a patent application is no less relevant than filing a high impact, getting a publishing and high impact research paper. So this is the overall aggressive strategy, which actually takes us from understanding what all things are around us to going and filing a patent application, understanding a state of art. So right now what is a defensive strategy? Before we are entering the market, what we can actually do? We can first need to identify whether we have someone else has actually filed a patent, actually got a patent grant on our area of operation, our jurisdiction of operation of an innovation which is probably, if not identical, but similar to a product. So if not identical, it is similar to our product. If so, then what do we call it? We call it infringement analysis. So whether our particular product can actually infringe or not. We can also call it freedom to operate, right? So then if we see it is actually identical, we do a design around search. What is a design around search? Design around is that, we can we develop the product in a fashion which will actually help us to, bypass that particular patent application. So if tomorrow an infringement suit comes in, we can tell, it might look similar, but we are doing it in a different way. And else, if it is actually identical, and when the suit comes, we go to the process of invalidation. To ask me what is an invalidation? Invalidation, where we do an analysis of the particular patent application which is identical to our innovation, and understand whether there are other prior arts which we can use to invalidate that patent. That, we actually apply to the patent office and tell them the criteria are there, and this particular patent shouldn't have been granted. That is the invalidation. So before going into the next slides, I would like to take up some questions. So any questions on this entire strategy part? Please raise your hand.
Prakash, ask the question in the end.
Okay, sure.
Go ahead.
Sure. Next, I'm moving to the next slide. So, do's and do not in startup and intellectual property. First thing is that protect your USP, protect your unique selling point. So, how do we protect our unique selling point? All the entire strategy part has been discussed. Then actually promoting your USP. And not only protecting and sitting over it will help. We need to actually promote our USPs that will actually help us to get commercial benefit out of it. If you are not promoting our protected assets, it won't help. So how do we actually implement these two simple do's? So we need to build a culture. Build a culture is building a culture around intellectual property, where people discuss about the assets they are creating, or envision that, their visions in a way and embed in a product. And then to build a culture, the first thing we need to be aware of what is intellectual property and its form. Then not only being aware of intellectual property and its form, it's very important to understand what is our IP, what assets actually I own, then about what assets which competitors own. Once we understand what assets I own, what assets competitors own, we actually understand our position in the market. Then secure communication with externals and internals. External means with external entities, like we are going on a business communication, we are going on a paper publication. Those communication will be in a way wherein there are places where we can actually divulge our intellectual property to showcase our talents, and there are ways we can actually hold back to hold our intellectual property, actually protecting it, because probably there is enough time for now to nurture and build the product. And once we have substantial assets, and then we can speak about licensing our intellectual property and generating a non-linear revenue channel. And then we move into cost optimization and revenue generation. Once we have a patent portfolio, the major objective is that saving on the annuity fees. We basically look through the life of the IP. We understand for which we can actually continue paying annuity fees, and for which actually we don't need to pay annuity fees, and understand what is our revenue generation and what is our ROI from filing all these intellectual properties. So, and right now I will be discussing some statistics, and these statistics has been taken from intellectual property offices, Indian intellectual property offices annual report, and over there what we have seen that around 10 patents has been granted in the year 2016 to 17. This is the latest data that was available, and if you see the number of the top five companies and institutions that have filed patents in the intellectual property in the information and technology and ITES domain, we find the name of one startup in number 3. After Wipro and Tata, we see, I will just use the laser one pointer. We see the name of Hike Limited, which has filed 66 patents, while TCS has filed 90 applications. And then we see a name of a professor, Dr. Kanapathy Gopalakrishnan, who has filed 36 applications. So what I went through, I actually do a background on Dr. Kanapathy Gopalakrishnan, and I saw that, that he is the Dean of the New Horizons Engineering College, and he has filed all the patents on his name instead of filing in the name of the college. Ideally, a particular inventor should be a particular person who is a professor of a college, probably most, and envisioning the invention within the college and the academic framework, it should be filed in the name of the college or the university. Like, if you see SRM University has filed 32 applications in information technology domain, right? So over here again, we see what we see. There is a comparison of the number of patent files by natural person, the startups, the small entities, and other natural ONPs. So we see that small entities or MSMEs, they have filed 412 patents in 2016-17 and 491 in 17-18. For in startup scenario, what we see, the increase has been almost 200, more than 300 times. It's 160 in the year 2016-17, and in 17-18 they have filed 511 patents. So 160 to 511 patents. So if you ask me why this rise is because of all the government benefits they are getting, and in order to register, they need to establish the uniqueness. In order to establish the uniqueness, innovation and technology process, the easiest way is to go and file a patent application. Excuse me. And but the foreign publication for foreign filings are pretty less. It's 3 or 4. Okay, and startups are also actually working, taking all the benefits and criteria that benefits and rules that are available within our patent act, like request for expedited examination to examine their patents at a very small turnaround time. There have been 161 applications, and there have been 10 patent grants also. So these are the patent statistics, and it's a very, very wise scenario that at this point in time that is going through. Now I will be speaking on few case studies. Okay, so probably when I was a kid, I have seen this Singer machine, right? So how one of the earliest patent trolling, I would say, was done by the Singer Manufacturing Company in the year 1860s and 1870s. Then they went and filed a patent for the Singer automatic, and they didn't allow any other player to operate in the market for this automatic weaving machine, the table weaving machine, and they monopolized the entire industry then, and actually established their group. And then only, excuse me, just let me share my screen, please. Can you hold on? Okay, I'm just sharing my screen. Okay, so then they went ahead, actually monopolized the entire industry, and for which major Monopolies Act came in. So I will show you the patent application for Singer. Please hold on. So this is the Singer patent application. It was patented in the year 1851. Probably even today also we will be able to see this machine. I'm just running through the patent application. The entire structure was given. And the name of the person is that Isaac M. Singer of New York. This particular patent application helped him to establish the Singer Corporation. Okay, then, so speaking about 1860, how it is relevant, 1850, how it is relevant. It is relevant because uh, we don't learn from our history. Probably still also in India, we are not into filing such, novel applications and establishing our technology prowess. So I will give an example of India, but before that, let's speak about this particular car. So if we look into this particular car, what we speak is what we think about is Ford Model T. So Ford Model T is an industrial, case study. How a particular process line was used to dominate and just change the scenario of the entire automobile industry in United States. But we don't speak about, what actually forced Ford to, build this particular processor, build this particular Model T. So there's an interesting story about a patent attorney. His name was Mr. Selden. So he actually drafted one particular patent called Selden patent, and he took the recourse of the US Patent Act then and kept the patent live for 17 years. Before which, after which he went and sold that particular patent to a particular patent troll, which they used to call as automobile manufacturers of America, of North America, sorry. And until and unless you are paying huge license fee for that particular patent, no one was able to manufacture any automobile in United States. So Henry Ford went ahead. He went ahead and he told that he won't be paying the license fees because the price of the license fee was exorbitant. And he went ahead and faced the patent litigation, wherein that the Selden patent was actually invalidated on the ground that it was very obvious. So what are the major part of the patent I have put in? They have mentioned that this particular line, that it would have a steering mechanism, either one or several clutches, cylinders, a clutch, a brake, and so forth. What Henry Ford went and argued, he told that based on previously there was steam generated automobiles also, carriers also, which actually had cylinders, clutch, brake, and so forth. So any person skilled in the art can go and envision that tomorrow, if there is a fossil fuel generated automobile, it will genuinely have this particular features or components. But in the long run, but by that time, the Henry Ford went ahead and argued in US courts that that this is particularly this patent is obvious and it shouldn't have been granted, and invalidated the patent. Already they have earned for 30 odd years and monopolized the US market the way Singer did in 1860s. So I will be showing you the patent application. It was filed in the year, patented in the year 1895 by G.B. Selden. So this is the application, and this is the diagram. This is steering, the wheel. The engine was on this is basically front wheel driven. If this patent was probably alive today, this would have been a technical ground on a road engine. So any automobile which has a fossil fuel driven engine would have come under the purview of this particular patent, and based on which he monopolized the entire automobile industry for more than 20-30 years, odd years, before Henry Ford came in and challenged it in the court of law. So so again the question might come in, why I am speaking about 1895. So as a Bengali born and brought up in Kolkata, we all know about that Acharya Jagadish Chandra Bose. We speak that he actually went ahead and showcased radio wave communication in Mahajati Southern in 1894. And Marconi went ahead and showed it in 1895, and then actually he, but still people calls Marconi the inventor of radio wave communications. But what we don't know is that Jagadish Chandra Bose has also filed a patent application in the year 1905 on radio wave communication. Just I want to show it. So this is it was patented in the year 1904. Detector for electrical disturbances. This is Jagadish Chandra Bose's patent. So whatsoever Tesla challenged Marconi's OS on wireless communication, and there was a case in US Supreme Court, Marconi versus Tesla, wherein Tesla went ahead and invalidated Marconi's patent, showing that Marconi actually copied a lot of technologies from here and there, and which involved few published paper of Nikola Tesla. And based on based on that particular single Marconi's patent, Marconi actually established the Marconi Communication Company, through which he started generating licensing revenue out of his patent. Sheldon, Marconi, everyone, they started operating out of a single patent. If you look into history of General Electric also, General Electric actually evolved based on Thomas Alva Edison's patent. So based on, and I would say, I would conclude this particular presentation and open for question by telling that intellectual property and patent rights has been very, very important, not only in the year 1860s. It is still important today, but what happened is that we are still not aware. Like, if why we are not still not aware? Because there is not there is a lack of IPR aware culture in India at this point in time. The day we are aware, probably we will be filing more patent application and showing our technology progresses more to the world. So thank you, and I would like to open up the floor for questions. So if you have any questions, please raise your hand.
Yeah, definitely. Any questions?
Sure.
Good morning, everyone. I have a question regarding the startup benefits given by the West Bengal government. Can you elaborate on this topic?
So there is no specific state government benefits. It's mostly central government benefits, but I have not yet come across a major state government benefit. But yes, there is a program that is run by NASSCOM's 10,000 startups. Over there, infrastructure benefits are given in collaboration with West Bengal government. Like a space in the STPI, server spaces, license to a lot of software that are used for inventing ITS solutions. That is one thing that I'm aware of. And the rest are more all central government benefits, like benefits for lesser earnest money deposition for applying for tenders or government contracts. Those kind of benefits are given.
Okay, thank you.
Okay. Any more questions? Yeah, Mr. Chaudhary, Sally Chaudhary, please go ahead.
Yeah, very good afternoon. If myself is planning for a startup and I want to hire some new employees, and suppose if he or she is from one of the competitor firm, and then will there be any legal issue? especially if I want to avoid any litigation like leaking of their personal thoughts or like that, then will there be any legal issue or any precautionary measure?
Yeah, there actually can be a legal issue, like, if that particular first, there can be multiple legal issues you can think about. First thing is that whether that particular employee is bringing in any intellectual property from their from his or her previous company, like, any code base that he is bringing in, or any assets if he is bringing in, and or probably any idea he is bringing in that they have already patented it, like anything that he is bringing in that can actually lead to confidential information theft can be a problem. But that but the question will be that how will you understand, how will you actually be aware that he is bringing in someone else's assets to your organization? It's very hard to control it. Okay, even if Loxton gets it there, very hard to control it, but it can be actually handled by a proper employment agreement. Like the employment agreement, if that a particular employee uh, agrees to indemnify your company for all future litigations that will be arising out of his actions, right? If he is doing the theft, if someone is coming and suing you for a particular amount of money, probably he will need to indemnify for all the legal costs and the damages and all the hours probably that particular company is uh, getting from court against you. So if such an arrangement can be done contractually, probably that can be the best safeguard. And other than that, there are established uh, organization processes and policies that should be embedded for a startup in order to minimize such these kinds of leaks.
So I think then it would be better just to avoid if he or she is from my competitor firm or like that, isn't so?
No, it won't be better to ever say at the same time probably you might be missing on a very wonderful resource. The question is that there are established safeguards in the industry. There are established industry practices that should be followed in order to safeguard ourselves, and then at the same time look into our benefits. Like, if tomorrow probably the major headhunters, if you see in the IT industry, the major headhunters are probably TCS, Cognizant, Wipro, and Infosys. If they stop hiring each other's employees, thinking that probably we will be facing a litigation in future, they would have missed on wonderful resources who have been contributing to the industries in wonderful ways. Instead of doing that, what they did, excuse me, they established industry standard processes to minimize such risk.
Thank you.
Any more questions, please?
Okay, I think no one has. Oh yeah, one more. Mrs. Rupal.
Hello.
Yeah, please go ahead.
Yeah. So, for a startup, like it is not a surety that they would have the required funds. So, in case if a startup wants to dilute their shares or equity in order to raise some funds, is there any approximate percentage that they can dilute their shares up to?
No, there is no approximate percentage. So if you are speaking about strictly from the funding point of view, a seed fund or probably a Series A, Series B, Series C funding, if you're looking at, it totally depends on the negotiation part. So there are pre-negotiation processes and policies that people should embed. Like, if you have a patent application on your name, and you are the main inventor of that particular application based on which the startup is running, and you are the CEO of the company, and you probably will have a better negotiating power. But and then for seed also, there are specific funders, or angel funders, or HNIs, high network individuals. They worked on fixed rate, like IIM Kolkata. They operate on a 3% equity rate for seed funding, and based on that 3%, based on the technology prowess, they actually give seed money capital anything from 50 lakhs to 5 crores probably.
Against
Okay.
3%. Against 3%.
Yes, against 3%. And for Times of India's group, they probably take 10%. Ambuja Neotia, the standard is around ranges from 5 to 15%. So it depends on negotiating power. So before you go and raise your fund, it's always good to establish the technology prowess of the company, showing the market growth, the commercial applicability and viableness of the product first, and then then we can actually go and negotiate it properly and negotiate within their comfort zone, of course.
Okay. Okay. Okay, sir. Thank you.
Any more questions?
I think there is no more questions. Yeah. Thank you, Prakash, for this wonderful session. Prachita?
Yeah, yes, sir. Okay, thank you so much, Mr. Prakash Dev, for such a wonderful session. I'm sure the doubts that we had regarding startup and IP process, that most of the doubts has been cleared over here. It was very much the entire session has enlightened us to a greater extent. Thank you so much for joining with us and sharing your valuable thoughts with us. See you tomorrow, everyone. Once again, Sarah will be there in tomorrow's session with technology transfer. Okay, thank you so much, everyone, for joining with us. See you all tomorrow at 11 a.m. Thank you.
Thank you.
Thank you.